Bueno, hola a todos y a todas. Gracias por estar acá. I will now switch to English to be in line with our speaker. So welcome to this master class of AI and competition law. As you many know, SECO has closely followed the different discussions about digital markets and digital economy, always trying to put a focus on the United States and also in the European Union. And in that context, today we have the privilege of hosting Professor Adrian Kuenzler, that, among other virtues, can handle pretty well both jurisdictions. So Professor Adrian Kuenzler is an associate professor at the Faculty of Law of the University of Hong Kong. He's also an affiliate fellow at Yale Law School. He holds a PhD in law from the University of Zurich, and he also holds a Juris Doctor from Yale University. And his research is related to competition, of course, but also technology, innovation, and he has published many papers on those fields. So we will now give the word to Professor Kuenzler for approximately 40 minutes. And then at the end, we will open the floor for questions from the audience for about 15 minutes or something like that. And so, Professor Kuenzler, thanks again for being here today with us and for your time. And the floor is totally yours.
Thank you so very much, Juan Pablo, for the kind introduction. It's a great pleasure to be here today. I was truly happy to receive the invitation for this masterclass, and I'm deeply grateful to the CentroCompetencia and the Universidad Adolfo Ibáñez for this opportunity. So I'd like to extend special thanks to Felipe for the honor of being here, to Juan Pablo and Bruno for the excellent organization, coordination of this event, and also to the ASCOLA Latin American chapter for their valuable support. So over the next 35 or 40 minutes, I will offer an overview of recent developments in competition law enforcement in digital markets, focusing, as Juan Pablo said, particularly on the EU and the US. And I thought that in keeping with the spirit of a masterclass, I will assume some familiarity with the key issues that we discuss. I will try to aim to provide a fresh perspective, one that goes beyond a standard summary of existing knowledge or case law. So I hope that this will encourage some deeper engagement, reflection, and hopefully also some discussion. Now, as you said, Juan Pablo, the presentation is divided into two parts. In the first part, I will look at recent competition enforcement in the EU, and in the second part, I will focus on emerging litigation in the US. Now, when we talk about competition enforcement in digital markets, I think it is helpful first to keep in mind that in recent years, a number of important empirical studies have observed rising concentrations of corporate power. In turn, policymakers and scholars have maintained that competition law should be employed to restructure markets by breaking big technology companies up or by divesting them into separate units. Recent enforcement practice, especially in the EU, shows, however, that dealing with digital economy issues extends beyond these claims because digital markets differ significantly from traditional ones. In the digital economy, a central challenge for competition law also relates to its enforcement and to the practical exigency of fashioning and implementing appropriate remedies. So to give some structure to this first part of the presentation, I will focus on three main points. First, I will provide some very brief background to the ongoing debate. Then I will discuss leading case law and examine how recent competition enforcement has addressed novel types of harm in the digital economy. And finally, I'll draw some conclusions to reflect on the broader economic and perhaps also societal implications of these developments. But let me first give you a brief overview of the existing debate, but I will keep this as brief as possible. Now, legal disputes around data-driven markets regularly turn around the major internet platforms' illegal acquisition of small competitors their characters, monopolies, and their preference of their own related products through network algorithms, resulting in harm to competing producers. Moreover, there are concerns around the platform's size and reach, which highlight the risk of suffocating progress, intensifying inequality, and exacerbating social and political polarization. Now, to address these harms, policymakers have maintained that competition law should be employed to break the companies up or to divest them into previously acquired entities. Proposals such as these, however, contain a complex tension. Because the dominant platform's activities present risks in economic and non-economic terms, competition law either needs to be repurposed to deal with a broader set of values, or is required to refrain from dealing with non-economic issues altogether, issues that are perhaps better dealt with by laws designed specifically to target privacy, data security, fake news, and so forth. Now, the problem with this view is that distrust in the sheer size of big technology platforms and the reach of their activities obscures the network benefits that these platforms generate and that they may augment by expansion into the future. So the tension is in large part a consequence of a long debate in legal scholarship as to what goals competition law should pursue, whether competition law needs to be focused exclusively on consumers, competitors, or both, or whether it should also attend to the social and political harms of market power. Now, when we look at recent enforcement practice in the EU, we can observe something interesting. Rather than focusing on the goals of competition law, I think competition law enforcement reflects a shift in emphasis in at least three important respects. So first, competition law enforcement has increasingly turned around the issue of how quality rather than price competition works. Existing doctrine so far has underscored that markets will inevitably correct themselves. So the basic theory is that if consumers have choices and there are cheaper substitutes, they will simply head for the alternative. Less attention has been paid, however, to deteriorations in product quality in data-driven markets with a zero price. So the issue here is how can quality degradation, such as excessive amounts of data collection, unmet consumer expectations, or covert redirection of users' attention in dominant firms be forestalled? A second issue is how consumers can navigate data-driven markets when switching between different products is no longer the main disciplining mechanism on the behavior of dominant market actors. Most policy proposals seek to provide consumers with a right to switch through data portability or interoperability measures. Alternatively, policymakers have envisaged, again, forcing big technology companies to separate from some of their essential services, to reinstate consumers' choices, and to lessen the adverse effects of dominant actors on other players. However, recent competition law enforcement in the EU shows that as a result of a growing extent of product customization, personalization, or maybe even manipulation, consumers' choices are perhaps best put into effect if consumers can help to challenge, contest, or modify their favored segments. And the third issue concerns the relationship of competition law and regulation. Especially with the introduction of the Digital Markets Act, the debate has turned around ex-ante regulation versus ex-post legal interventions, and whether competition law can effectively address the predicaments of data-driven markets. I will not elaborate too much on this point during this presentation, but existing case law highlights the importance of ex-post competition enforcement even in the presence of ex-ante legislation. So this brings me already to the second point. Let's take a brief look at recent enforcement practice and what we can observe from it. Now, the most significant recent cases in the EU highlight that data privacy has become a main concern for competition authorities and courts. Of similar concern is the ability of digital platforms to favor native content and to steer and redirect parts of the customer journey on the internet. So the influence that these platforms have can be utilized to the advantage or detriment of market actors and consumers to affect the variety of commodities used and cultural content consumed, and sometimes even to amplify or bury distinct voices in public discourse. What's more, the growing presence of artificial intelligence-based algorithms frequently distorts the classical distinction between production, distribution, and consumption. For example, decisions taken by consumers in the digital economy are increasingly made passively through implicit or explicit product matching and personalized recommendations rather than through active search. Such algorithms recommend and purchase products based on spoken, written, or inferred requests obtained from users of digital platforms or devices such as mobile phones, speakers, and smart assistants. Now, of course, these algorithms benefit consumers in that they facilitate more complex, more swift transactions, and they diminish consumers' search and transaction costs. But they also work to entrust the ability of consumers to actively search, including their capacity to pick and choose, to big technology firms themselves and place consumers' decision-making power into the hands of producers. And this creates opportunities for misaligning the preferences of consumers with the goods and services actually sold, causing harm to customers, competitors, and the market, including society as a whole. Now, to remedy such harms, competition law usually ensures that consumers have an opportunity to choose between different alternative options. This is the equivalent of the conventional idea in which efficient markets afford consumers an ability to switch between distinct providers so that they can pursue their own commercial transactions at their individual discretion. But in concentrated markets, consumers typically are no longer able or indeed willing to choose effectively between alternatives. And this is why, in theory at least, competition law is meant to break big technology companies up, to reinstate the ability of consumers to choose between different alternative offers. Now, in practice, when we look at recent case law, we have seen very few breakups and or divestitures, if they have occurred at all so far. Instead, competition enforcement has taken a different form. Competition authorities and courts have increasingly focused on big tech platforms' terms and conditions of agreement, their technological design choices, and their overall business practices. So let me illustrate this point briefly. When we look at recent case law, we see that competition authorities and courts have focused on how they can hold big tech companies accountable, how they can make them understand why consumers are dissatisfied by finding novel ways to remedy the platform's lapses rather than simply focusing on market structure by breaking the companies up and creating more alternatives. So, for example, in the recent investigation into Facebook's data collection practices, the German Federal Cartel Office found that the design of Facebook's platform imposed upon consumers the sort of all or nothing choice that left users either having to agree to unlimited data collection or not using the platform altogether. So here the authority recognized that the most effective way to safeguard competition and to protect consumers' privacy was not to break the company up, but to require Facebook to incorporate additional technological features into the platform, enabling users to opt out of the platform's data gathering. The authority's ruling has been confirmed by the German Federal Court of Justice and recently by the Court of Justice of the European Union in its Meta judgment in 2023. Now, in a similar manner, the European Commission in Google Search Shopping found that users who were bound by Google's dominance in the search engine market had unknowingly been exposed to Google's inbuilt algorithms favoring Google's own comparison shopping service over those of rivals. Here, the European Commission inflicted upon Google the obligation to ensure that Google treats competing comparison and shopping services no less favorably than its own comparison shopping service within its general search results pages. Again, the ruling has been confirmed by the European General Court and by the Court of Justice of the European Union, the highest court in the EU. So this approach relies on integrating consumers' preferences within dominant platforms rather than separating them. And this has also been considered more appropriate for addressing claims brought against Apple's App Store, requiring the company to enable side loading of or interoperating with third-party applications. And similar remedies have been proposed with respect to dominant online marketplaces' anti-competitive practices. So I think the case law points to a novel way of protecting competition and promoting innovation by combining three strategies that are typically used separately. So first, it is recognized that in principle at least, consumers need to be able to choose between different platforms to maintain autonomy. Next, it is acknowledged that different providers must be interoperable, so switching platforms and migrating data must be practical. And finally, perhaps most importantly, consumers' preferences should be considered and used to improve existing services such as feature addition and product design. So existing case law seems to view these strategies as complements rather than substitutes, which enables authorities and courts to better navigate product quality degradations and to achieve effective regulatory policy decisions. Now, with this in mind, let's move to the broader economic and societal impact of the case law and this approach. So when we look or when we think about the broader economic significance that new technologies currently have in our societies and economies, we recognize that the ecosystems of dominant platforms progressively determine which innovations are brought to market, what goods and services are purchased, how revenues are distributed, and what choices consumers can make. What's more, digital platforms increasingly affect the marketplace of ideas, pluralism, democracy, and the political process. So the incentives that big technology platforms have crucially affect the economy and society at large, but these platforms do not necessarily care about what consumers want and what society needs. So the larger point is that competition law can make technology care for societal goals if it can help align the platform's underlying incentives with the preferences of consumers, citizens, and ultimately society at large. Authorities and courts investigate data-driven markets on behalf of consumers to ensure their views determine the market's state of quality equilibrium. This does not necessarily entail repurposing competition law or requiring it to deal with non-economic values. Rather, it requires intensifying the law's enforcement to render concentrated markets more responsive to consumer interests. More to the point, the case law shows that competition law can render dominant social media platforms more privacy protective, that it can compel dominant search engines to meet users' expectations, and that it can help build app stores and online marketplaces that refrain from discriminating and better accommodate consumers' preferences. So competition law necessitates terms and conditions of agreement, technological design choices, and business practices based on the preferences of consumers and the platform's user base, not only on those of advertisers and big technology firms themselves. And I would like to clarify this point briefly before we turn to the second part of the presentation. I will use the Facebook investigation again as an example, although the broader point I think equally applies to cases I mentioned earlier. Now, in its investigation, the German Federal Cartel Office found that Facebook collected excessive amounts of user data without users' actual knowledge and consent. The authority required Facebook to give users more control over their private information, enabling them to withdraw their consent partially or completely and to turn off tracking across the horizontal market. Now, this enabled consumers to limit the information that appeared and was disseminated on Facebook platform. The remedy also benefited third-party websites and applications because they now remained the main gateway to discover new products and content. And rather than breaking the platform up, the platform could maintain its size, benefit from economies of scale and scope, including network effects, make new investments, and even add additional parties to its network. So before the authorities' intervention, Facebook simply looked at its incentives. It did not provide consumers with an opt-out right, although this would have been relatively easy to implement at scale. After the authorities' intervention, the market grew more responsive to consumers' preferences. Consumers could limit the platform's data tracking. The significance of privacy was growing. Other companies that sought to accommodate consumers' preferences could benefit from doing so and could gain a competitive advantage relative to those that paid only minor or no attention to what consumers were willing and able to demand. Some came up with novel technological features, others established alternative funding methods for advertising and monetization of digital content. And again, others explored solutions that involved consumers in the sale, sharing, and negotiation of fair market value for their personal information. So, of course, this is not to claim that competition law can solve the entire privacy problem or other problems related to the broader societal implication of these technologies. But I think recent competition investigations have contributed to a significant mitigation of these issues for users, competitors, and affected parties of the population. I think the point is that the simple creation of more alternatives achieved through breakups or divestitures does not always lead to better outcomes. In most cases, we see that more targeted, sometimes even more modest competition interventions may prove to be more effective in restoring and safeguarding competition. Now, because of time constraints, I think we should move to the second part of the presentation. Let me see exactly. So the first part has dealt with the impact of new technologies and digital markets more broadly. Now, in the second part, I would like to focus specifically on the use of artificial intelligence or AI by market actors to coordinate their behavior or to leverage their influence to the detriment of competitors. The issue has become particularly relevant in the US context. Now, again, I think it's important to recall that recent empirical research shows that the use of AI in the market context can lead to tacit collusion among firms by learning how to coordinate prices without engaging in explicit communication. Where algorithms are used to collect and analyze widespread customer data, new technologies can also promote sophisticated price discrimination by tailoring prices to individual consumers based on willingness to pay, loyalty, or specific product attributes. Now, these two issues, tacit collusion and discrimination, can bring about artificially inflated prices for consumers and can lead to the exclusion of competitors, all without direct human involvement. In sensitive sectors such as healthcare or insurance, algorithmic bias can cause unfair market valuations and undermine the competitive process. A prominent example is the evolving interplay in the United States between state legislation and competition law enforcement concerning algorithmic rent-setting practices. In 2024, a policy paper released by the Council of Economic Advisors found that algorithmic rent-setting software cost US renters an estimated $3.8 billion in 2023 by facilitating price coordination amongst landlords. The report framed such conduct as a modern form of anti-competitive behavior, emphasizing that price fixing remains unlawful even when mediated by algorithms rather than human agreements. The Department of Justice and several states have filed lawsuits against leading rent-setting software providers, and they highlight that algorithmic collusion is a priority for competition law enforcement. On the other hand, several states and cities have proposed or enacted bills seeking to ban algorithmic rent-setting software outright. So we focus on competition law here. Of course, when it comes to competition law, I would like to share a few real-world examples again that illustrate how the issue plays out in practice. These are a couple of examples regarding ongoing litigation. So the first example is the RealPage litigation. RealPage is a software producer and seller that centralizes competitively sensitive data from landlords across the US. Landlords send proprietary pricing data to RealPage and receive rent recommendations based on aggregated competitor information. This establishes a classic hub and spoke structure in which RealPage enforces coordination by monitoring compliance and nudging landlords to accept uniform prices. So the alleged effect here is artificial inflation and stabilization of rents, replacing independent decision-making. The Department of Justice argues that this is a Sherman Act violation through facilitated algorithmic price fixing. I just got a message recently, some of you might have seen this as well, that RealPage settled on this case in the past couple of days. Now, a second example is the Cornish Adibici litigation. Here it was alleged that casinos formed a hub and spoke conspiracy via a central pricing software to fix room rates. Here there was insufficient evidence that casinos shared confidential data or coordinated pricing decisions. There were varied software adaptation rates which further weakened the conspiracy claim. So the case was ultimately dismissed, which underscores that merely using the same pricing tools or showing parallel pricing is not enough to prove the existence of an illegal agreement. And so, of course, this emphasizes caution in inferring collusion solely from shared technology. Last example is the Yardi litigation. Here, plaintiffs claim that Yardi's software connects landlords in sharing sensitive pricing data, fostering coordinated price inflation. The allegation hinges on whether landlords knew competitors were contributing data and following common algorithmic outputs. The case is pending, with the court evaluating whether data exchange amounts to a tacit agreement or constitutes lawful independent decision-making. I think this case again highlights the blurred lines in antitrust law between algorithmic facilitation and illegal collusion. Now, all these cases deal with the question of whether the use of algorithms in the market amounts to an agreement, but the use of AI in the market context can go much further, actually. So sellers can simply instruct their software to maximize profits, and the algorithms autonomously figure out that coordination on a super competitive price best attains that objective. Algorithms also learn to systematically adopt discriminatory strategies by charging different prices to different customers, while these differences do not depend on production costs, but are set on the basis of individual willingness to pay, which can lead to discriminatory treatment and the exclusion of competitors. At present, there is no case law that conclusively addresses or resolves these issues. And so I would like to share some preliminary thoughts on how AI affects competition on data-driven markets. And of course, these are my own views, but hopefully this is insightful. So I argue that the progressive use of AI technologies requires a fundamental shift in how we conceptualize data-driven markets and how we apply competition law in this space. because from a competitional perspective, tacit collusion and price discrimination are typically not deemed illegal, but their outcomes are inherently undesirable. So let me again structure this a little bit and highlight three distinct points. I will first again offer a few brief remarks on the ongoing debate around algorithmic collusion and discrimination. Then I will argue that AI turns two of competition law's most fundamental assumptions on their head. And third, I outline some possible directions for the future of competition and AI in the digital economy. So let's first briefly look at the existing debate, and I focus exclusively on AI collusion and discrimination. Now, disputes around algorithmic collusion and discrimination typically revolve around the ability of AI in the market context to raise prices, to exclude competitors, and to cause harm to consumers without human intervention. Furthermore, there are sector-specific concerns around discrimination, such as in health or finance, where the use of algorithms can result in unfair market valuations. Scholars increasingly argue that AI renders tacit collusion and exclusion more prevalent and realistic, and that the law should take a stricter posture in relation to such conduct. Legal scholarship also acknowledges that firms are increasingly aware of AI's pernicious capabilities and that it is gradually more attractive for businesses to utilize AI in the market context. Relatively scant attention has been paid, however, to the fact that current legal doctrine struggles to address algorithmic collusion and exclusion. This is because competition law typically focuses on contractual relationships and assessing market conduct, not just market outcomes. And this is why I think that competition law, at least in principle, is ill-suited to incorporate liability for AI-driven market behavior. In particular, AI confronts competition law with a fundamental tension. So if competition law aims to prohibit AI because AI increasingly leads to harmful market outcomes, competition law needs to reject the conventional assumption that firms behave as rational, profit-maximizing actors. Conversely, if the use of AI in the marketplace is presumed lawful, but some of its outcomes are nonetheless condemned, competition law must revisit its existing doctrinal tests for establishing infringement, which associate market conduct with performance. Under this alternative, liability will be based purely on the outcomes generated by AI rather than on the intent or nature of the conduct, effectively creating an outcome-centered regime of competition law liability. So the tension stands for a fundamental choice: either discard the rationality assumption or abandon conduct-based assessments in favor of outcome-oriented competition law liability. Now, of course, the question is why? Why do algorithmic collusion and discrimination confront competition law with this said tension? And let's take a very brief a quick look at competition law's assumption of rational and profit-maximizing firm behavior first. I cannot elaborate on this in detail, but we know that competition law traditionally assumes that firms face significant risks and uncertainty when competing because the outcomes of any competition are or should by definition be unknown. And this uncertainty requires that competition law focuses on market conduct rather than outcomes. This means that firms are allowed or indeed incentivized to exploit existing profit opportunities. And from this, it follows that in case of doubt, parallel interdependent firm behavior regarding fundamental matters of pricing or disputed cases involving discrimination are not held to be unlawful. Only practices that demonstrably involve anti-competitive collusion or exclusion can justifiably be condemned. Now, AI inverts that assumption because AI significantly diminishes market uncertainty by enabling firms to analyze the behavior of their rivals and predict consumers' preferences with unforeseen precision. This means that AI-driven collusion and exclusion may become more likely even if firms do not intend to act in anti-competitive ways. And this is because AI-driven collusion and exclusion are often the result of advanced analytics rather than deliberate misconduct. So condemning AI simply based on undesirable market outcomes would force firms to ignore profit-maximizing incentives and sometimes act contrary to their motivations. As firms progressively use AI systems that are designed solely to maximize profits, it becomes very difficult to classify their conduct as unlawful under existing legal standards. I think AI also upends competition law's basic tests for establishing infringement. Competition law typically requires linking firm conduct to anti-competitive outcomes. That is, a firm's conduct must have caused or contributed to an anti-competitive outcome. In practice, of course, courts often infer infringement by correlating market outcomes such as uniform or discriminatory pricing with circumstantial evidence such as particular market structures or cost asymmetries. Now, again, I think this analytical framework at least partly collapses in the context of AI. Collusive or exclusionary outcomes may merely reflect independent, rational responses to market data rather than unlawful coordination or discrimination. This means that when AI is involved, authorities and courts would have to look beyond mere market outcomes and assess whether the AI itself engaged in unlawful behavior. This turns out to be challenging, of course, because AI behaves in fundamentally different ways than human actors, and the reasoning behind AI-driven business strategies is typically not accessible. So if authorities and courts nonetheless seek to condemn uniform or discriminatory firm behavior when AI is involved, outcome-based liability will grow in importance and the significance of conduct-based assessments will decline. Now, of course, the question is, what's the way forward given these complications? There must be a way forward. So first, I mentioned it at the outset, especially in the United States, we see that several states and cities have introduced new rules that address algorithmic price discrimination in context where competition enforcement may be insufficient or ill-suited to address harms arising from non-transparent AI systems. Some jurisdictions have introduced information duties specific to algorithmic price discrimination. Other jurisdictions have introduced bills requiring businesses to disclose to customers when a price or a contractual term is set or recommended by an algorithm. And again, other jurisdictions have introduced opt-out systems that can serve as protective devices, affording individuals or groups the ability to refuse personalized or discriminatory pricing. Now, of course, there are many benefits to this kind of legislation, but I think that regulating AI in the market context will not resolve the underlying competition problem. Prohibitions of AI technologies seek to address the contributions of AI, even if most of a firm's behavior did not originate from them. For instance, regulation may assume that firms are aware of the risks associated with AI, and some laws already do so. But if competition authorities and courts in a specific case cannot demonstrate a clear understanding of the AI's underlying working logic and cannot monitor the algorithm's behavior in real time to prevent anti-competitive effects from occurring, the concepts of collusion and exclusion, I think, will diverge significantly from the meanings these terms currently hold in competition law doctrine. So I think that competition law will, at least in this space, likely assume a very different shape, especially in the context of AI, and establishing infringement will become considerably more challenging. Now we can think about this as such. I think this shift is not inherently problematic. Competition law intends to incentivize rational profit-maximizing firm behavior when market outcomes are unknown. So it's therefore plausible that competition law will or should assume a diminished role when much of the discovery that we value no longer originates from human ingenuity. However, if AI leads to a greater extent of collusion and exclusion, and there is mounting pressure to condemn non-competitive market outcomes, authorities and courts will increasingly be required to make inferences of unlawful behavior based perhaps on the mere use and capacity of AI. Now, maybe this is not where the law should be headed. Perhaps a more refined approach involves recognizing some of the benefits of AI in the market context, maybe by enabling companies with high fixed costs to charge higher prices to less price-sensitive consumers and offering lower prices to price-sensitive customers. This will increase product affordability overall, result in a more diverse range of products that are tailored to several different segments. I think for competition law, the bottom line is that any resulting competition liability will need to strike a balance between lowering the threshold for legal intervention and giving rise to a multiplicity of standards and presumptions that allow for a finding of competition infringements in a greater extent of personalization. Now, I don't want to speculate about how this will play out in practice, but I think the goal of such an approach would certainly need to be to ensure that the enforcement of competition remains effective, especially in markets where new technologies allow firms to engage in dynamic and highly personalized behavior. I think we are almost through with the time, so I would like to stop here, open the room for discussions, questions. I thank you very much for your attention. I look forward to your feedback and questions. I have added a couple of slides for your convenience with literature. If you want to use this as a source, you are very happy to look them up. They're all available, open access. I hope that this is helpful.
Well, thank you very much, Adrian, for this very, very wonderful and interesting presentation, especially considering the mixture between theory and concepts and specific cases. That is very, very virtuous. So now we open the floor for questions from the audience. So if you have a question, please raise your hand and I will give you the word. In the meantime, let me go with one question. Actually, I have two of them. So I have one question about AI and collusion, another one for abuse of dominance and digital markets. So the first one about AI and collusion would be now putting the focus on the European Union competition law and particularly Article 101. Do you think that for making this fundamental choice that you mentioned between an outcome liability system and intent or conduct liability system, should the European Union legislator change the wording of Article 101, or do you think that, I don't know, the concept of concerted practice or an open concept of agreement can also be useful for the doctrine to interpret this fundamental shift that you mentioned? So that will be one question. And the other one regarding abuse of dominance. How can we measure quality in these cases? Because price, of course, there are a lot of econometrics that we can use for developing tools for analyzing change of price and stuff like that. But when we assess quality, especially considering that many of these platforms that doesn't have a monetary price because they are kind of free, how can we assess quality in those scenarios, and what would be the limit between competition law in this regard and consumer protection law? So those are the questions that I have.
Thank you. These are really great and very deep questions. Let me start with the first one. So you mentioned Article 101 TFEU, which relies on the notion of an agreement. And so let me first, of course, the problem in adapting law to AI, artificial intelligence, generally is how the law should deal with the use of entities that lack intentions. I think that's the main doctrinal problem that we have. Also, whether it's in tort law, contract law, IP and competition, the law generally makes liability turn on whether the actor who causes harm or creates a risk of harm has a certain intention or mens rea. There is a mens rea requirement. But of course, AI, at least the ones that we currently have, do not have intentions in the way that humans do. So if liability turns on intention and you use an AI, that might enable you to circumvent liability. And so, of course, from a legal perspective, we can think about what the best solution is to deal with this problem. We can employ objective standards that are familiar in many different parts of the law. So these legal standards either ascribe an intention to the AI or hold them to objective standards of conduct. And so one proposal in the literature is to apply an awareness-based approach, so that if a firm or an undertaking who uses AI, if they have been aware or should have been aware of anti-competitive outcomes, they are held liable. So the question is, your question is, does Article 101 actually contain such this kind of liability? So I would argue that conceptually this is defensible, but maybe it doesn't sit squarely within the current text, as you mentioned, or the doctrinal interpretation of Article 101, which again is grounded in the notion of agreement between undertakings. So the traditional framework requires evidence of explicit or tacit coordination, including communication or a meeting of the minds to establish anti-competitive agreements. And authorities and courts have typically demanded more than parallel conduct or adoption of similar algorithms. There must be circumstantial plus factors indicating coordinated action rather than mere independent use of common technologies. We saw that when we looked at the Real Page and Yardi cases. So I would say that one could argue that such an approach or regime represents a significant conceptual shift, may require, as you say, amending, reframing, revisiting Article 101. So the current formulation of Article 101 relies on the agreement paradigm, which assumes coordination, which is increasingly absent in AI-driven settings. So one could argue that incorporating such a standard would broaden liability towards outcomes or risks rather than conduct or intent, and would challenge fundamental principles such as the ones that I mentioned. On the other hand, you could argue that such an approach finds some resonance in EU jurisprudence. So especially the Ituras jurisprudence points to some standard that goes in this direction. So in Ituras, the court considered whether the platform users, so this was an airline system where travel agencies and airlines could enter prices, and of course this was then used to coordinate prices. So here the court considered whether platform users could be liable for competition or infringement on the basis of awareness of system changes that were communicated centrally, even if there was no explicit direct agreement between all platform users. So the ruling established that undertakings may be presumed to participate in a concerted practice when they are made aware of anti-competitive system use or programming, unless they actively distance themselves from it. So I think this shows that courts are not unwilling to extend liability in this sense beyond explicit agreements. But I would also think that Ituras still breaches traditional doctrine and new digital realities. It's not a wholesale adoption of such a liability regime for algorithmic collusion. So it provides some doctrinal support for integrating some of the elements that you mentioned, but I do not think that it embodies a full awareness-based regime that is suggested for algorithmic collusion in the literature. So I think we still have challenges to face, even in light of this jurisprudence. But it's a very important point, because especially in the EU, we have some precedents that show some willingness on the part of the courts to extend liability. Now, a second part of your question is regards quality. So how can we assess and measure quality in competition? Of course, existing economic approaches focus on price, output, things that we can measure, and quality tends to be very difficult to measure, especially also if you think about quality from the point of view of consumers. You could take privacy as an example. Some consumers might value privacy in one context, others might not. Same consumer might have different views on privacy in different settings. So it's very difficult to have an objective benchmark when it comes to quality, and that's why we can not really rely on economic insights here, although there is a very sophisticated literature on quality as well. So good examples are the Facebook example, the Google Shopping example. I think when you take the Google Shopping case, assessing, measuring the degree of quality in cases involving self-preferences, abuse of dominance in general, requires a very nuanced case-specific approach, especially again because the traditional market signals and monetary price are absent in these markets. So Google Shopping shows, for example, that excessive self-preferencing can lead to quality degradations. This was about relevance. Consumers expected the platform to show the most relevant results, and this is not observable. So how can we measure it? Very difficult to measure it. I think digital markets show, at least so far, that traditional mechanisms such as switching between consumers that are supposed to correct for this issue, they often fail, again, because quality effects are subtle, network-driven, or market alternatives are insufficient. So it requires us to look at all these factors. And so, of course, we have to look at each case to see what the effects of this are. And I would like to add a note, because there is often, I think, a misconception when we think about quality. I would not argue in favor of a neutral benchmark, an ideal platform that we have in mind, a neutralized platform as a benchmark. This is tempting. But I think, at least according to my reading, this is not what the case law suggests. This is not what Google Shopping suggests. What the court and the authority there said is that Google simply has to apply the same mechanisms to competitors and to its own services. It didn't say that quality or the outcome should be X or Y. So it left the choice of the mechanism entirely to the platform. And so this is very different from imposing a specific neutrality standard in terms of quality. So I think we always have to look at a plausible counterfactual in each single case where rivals have a fair opportunity to compete. It has to hinge on competition on the merits. The benchmark is not a hypothetical quality standard or a hypothetical perfect platform, but the competitive process itself, whether competitors have meaningful access and consumers have meaningful choice, and whether innovation and quality competition are preserved, regardless also of the type of platform and the type of quality parameter that we have in mind.
Okay, perfect. Thank you. So does anyone have any further questions? Just raise your hand or open your mic and we can hear you. If not, I have at least one last question from my side. And well, it is maybe this departs a little bit from your masterclass, but since you can manage pretty well both jurisdiction between the US and the European Union, I just want to know your insight on this. So Sam says that in the last years, and specifically in digital economy, somehow the US is creating the companies, is creating the innovation and wealth, and somehow the role assumed by the European Union is like to share or to distribute the wellness created by the US companies. So this is more like an international trade, maybe kind of topic. But what do you think about this relation between US approach, more laissez-faire, as you say, and the EU approach, more regulation based? I don't know if you have an insight on that.
Yeah, that's a good question. Of course, we see, and especially in recent times, we've seen, these kind of like competition law thinking being a little diluted by different rationales and so forth. But I think, so your question is more about the different approaches to platforms and the digital economy. So a couple of things. I think it's interesting to see that there is a different emphasis. That's one thing. Of course, priorities are different, and this depends, of course, on the market, on socioeconomic circumstances and so forth. We see more engagement with AI, collusive behavior, such, the case law that I mentioned in the second part of the presentation in the US. There hasn't been too much of a debate around that in the EU, and we can speculate why this is the case. But I think, these kind of technologies are very prominent here in the US, while in the EU, the issue has been much more around digital platforms. And so we see much more active litigation, both on the national and supranational level in the EU around platforms, search, social media, marketplaces, and so forth. And I would say that, of course, at the moment, to look at EU jurisprudence is very insightful for that reason. We kind of lack the case law that we have in the EU around these platforms in the US. Of course, we've had the Google Shopping, US Google case recently, but I think we have to be very careful, that there are labels, US Google case, EU Google Search Shopping case, but the emphasis is very different. So the US Google case, for instance, is much broader in scope. It primarily alleged that Google unlawfully maintained its monopoly in general search through exclusionary agreements, such as default search placements, browsers, mobile devices, and other conduct that blocks competition outright. So it focuses more on the traditional contractual structural restrictions in the search market rather than specific self-preferencing practices that we've seen being litigated in the EU within vertical search results. There has been, of course, an investigation by the FTC that has not been pursued, but if you read the former FTC statement very carefully, I don't necessarily think that there was so much of a difference. It's just that the FTC didn't pursue this, and then the EU, the European Commission, took it up and pursued it. So I think one thing that is often overlooked is that there are different priorities. And this has, of course, to do with the technologies that are prevalent in these markets. And of course, also in the EU, there has been an incredible activity on the part of national and supranational competition authorities, which has led to new legislation, which now is, of course, very prominent. And, because these platforms operate globally, this has gained prominence in other jurisdictions too. But we increasingly also see in this space that platforms do not necessarily adopt a global approach to these regulations, but they start to basically segment markets, that they allow different features in one jurisdictions in Europe than in the US and so forth. Maybe this is where it's headed. But it's interesting to see, and I think sometimes it's also important to distinguish very carefully despite existing labels. So Google Shopping, for example, is very different in the EU than the recent Google case that we've seen in the US.
Thank you. Thank you, Adrian. So, well, if no one has questions, we can end here. And at least, well, I speak for myself, but also for Seco, I guess that it has been really interesting and useful for us to receive this masterclass, especially that because always in Latin American countries we're looking abroad, mainly to the US and mainly to European Union, but there's this exercise of translating the concepts and the case law of those countries in simple word, in a clear way. It is really valuable for us. So thank you a lot, Adrian, for this, and surely we will be contacting you in the future for maybe another instance like this. And yeah, I don't know, Felipe, if you have a final remark, or are you okay? in this. Oh, sorry, I think your microphone is off. Yeah, well, don't worry, maybe.
Yeah.
There you go. There you go.
No, well, thank you very much, Adrian. And life is not easy. No, life is tough, even for the authority and practitioners. I mean, on antitrust, and I think based on what you have said, I mean, the future will not be that easy. No, with this connection between the enforcement of specific laws, regarding digital economy, and also the traditional way of resolving cases based on the old law. But it's also interesting, and we appreciate your view, and I think we have to put an eye, I mean, on what's going on, especially in the U.S. and Europe. I mean, to see all the developments. I mean, on especially on theories of harms, and especially on standards and presumptions. I mean, to make much easier to pursue a case. I mean, or a claim on our system. So thank you very much, and I think it was a very, very interesting view of what's going on in a very nice synthesis, I think. So, and hope to see you again very soon.
Thank you so very much, Felipe. It's really a great honor, and I have a great admiration for your work and for your jurisdiction. So I do think it's an interesting time for competition law, because, as you say, it's difficult, but it also gives us new opportunities. Maybe competition authorities experimenting with AI tools as well to counteract these developments and so forth. So I'm really keen to see what your take on this is, how practice will move forward. So it's been a great honor, and I hope we stay in touch, and next time in person. So thank you so very much for organizing this and for the honor of speaking to you. It's been a great pleasure.
Great. Thank you. Thank you again, and thank you everyone. Gracias a todos por venir y por darse el tiempo de estar en esta masterclass. Y bueno, muchas gracias.
Bye bye. Thank you.